Hi everyone, I am Wenxing Zhou and my group member is Zitong Kong. We are going to carry a presentation under the topic of continental shelf, and the presentation includes three parts. The first one is basic knowledge, the second one is a case, and the third one is some deeper analysis about it. Let's turn to the first part, basic knowledge about the continental shelf. We shall review some fundamental knowledge following the logic order of the book. First of all, geologically, continental shelf is an area adjacent to the continent or around the island extending from the low water line to the depths at which there is usually a marked increase of the slope to greater depths, and a legal concept is showed on the slides. According to the next clause paragraph 1 of the Article 76, we could know that the scope of the continental shelf is showed on the slides. I won't further repeat. Still, the question remains, how could we determine the outer limits of the continental shelf beyond the 200 nuclear miles? The convention provided two ways. It is showed on the unclosed Article 76, paragraph 4. But the most important part I want to mention in the basic knowledge is the commission of the continental shelf. As we all know, as the delimitation of the continental shelf is not only a political problem, but also it requires a lot of scientific skills to determine the outer edge. So, an organization called the Commission of the Limits of the Continental Shelf is created under the UNCLOS with the aim of determining the limits correctly and protecting the common heritage of mankind. What has to be emphasized is that the recommendations provided by the Commission would not have a binding effect until the states accept them. Let's turn to the second part. My partner Zitong Kong will introduce it for you.
Hi everyone, my name is Zitong Kong and I'm going to look at the second part of the presentation. Now let's turn to the case in 2012. It's a dispute concerning delimitation of the maritime boundary between Bangladesh and Myanmar in the Bay of Bengal. The International Tribunal of Law of the Sea made a court decision of the case on March 14, 2012. Let's start on the basic background information of this case. As you can see on the slide, the Bangladesh and Myanmar are adjacent states across the Bay of Bengal. You can also see their locations on the map. Bangladesh to the north and the northeast, and Myanmar to the east. For a long time, the two countries cannot reach an agreement on maritime boundary issues between them in the northeastern part of the Bay of the Bengal. On 8 October 2009, the government of Bangladesh instituted arbitral proceeding against Myanmar in the International Tribunal of Law of the Sea to resolve the maritime boundary issues, including the territorial sea, the exclusive economic zone, and the continental shelf in accordance with international law. Because our topic is continental shelf, so we are going to just focus on the part of the continental shelf in this case. And let's move to the next point, issues and judgment. About the delimitation of the continental shelf in this case, there are two issues. The first one is the jurisdiction between International Tribunal of the Law of the Sea and the UN Commission of Limits of the Continental Shelf. The second one is the basis of entitlement to delimitation of the continental shelf beyond 200 nautical miles. For the first issue, Bangladesh argues that there is no conflict between the jurisdiction of the tribunal and the commission in the delimitation of the continental shelf beyond 200 nautical miles. However, Myanmar, in the other hand, holding that even if the tribunal determined such jurisdiction to exist, it should not exercise such jurisdiction because the ruling of commission must come first. After looking at the circumstances of the present case, the tribunal concluded that it had an obligation to adjudicate the dispute and to delimit the continental shelf between the parties beyond 200 nautical miles. Such delimitation was without prejudice to the jurisdiction of the Commission. For the second issue, Bangladesh argued that the basis of entitlement to delimitation of the continental shelf beyond 200 nautical miles comes from the sovereignty over the land territory, while Myanmar believed that the boundary should be the outer edge of the continental margin. The tribunal concluded that the entitlement to the continental shelf beyond 200 nautical miles should thus be determined by reference to the outer edge of the continental margin to be ascertained in accordance with paragraph 4 in Article 76 in UN Commission of Law of the Sea. To interpret otherwise is warranted neither by the text of Article 76 nor by its object and purpose. And here is the text of paragraph 1 and 4 in Article 76 in UN Commission of Law of the Sea. The tribunal held that the source of the basis of the entitlement on the issue of delimitation of the limits of continental shelf beyond 200 nautical miles was not the principle of natural prolongation, but the principle of outer edge of continental margin. The reason is that the explanation of continental margin is more than that of the natural prolongation in the text of Article 76. Although natural prolongation is mentioned in paragraph 1 of Article 76, there is no further analysis of it in the following articles. However, it is clear from language of Article 76 that the outer edge of the continental margin is an indispensable element in determining the extent of the continental shelf, and it is argued that, and it is regulated in detail in paragraph 4 of Article 76. Therefore, the entitlement of continental shelf beyond 200 nautical miles should be determined on the basis of the outer edge of the continental margin as determined by the paragraph 4 of the Article 76. It is thus clear that the tribunal explicitly abandoned the principle of natural prolongation and introduced a completely new concept of the outer edge of the continental margin. And we think there are defects of the tribunal's view. Firstly, this view seriously undermined the status of the principle of natural prolongation, which had already gained international universal recognition at the time. Secondly, there are also influence on states which concerns the same issue in the future. The states may invoke this judgment to improperly extending their continental shelf and in the end leading to the erosion of the international seabed area and damage benefit of mankind. And now let's turn to the third part of our presentation, and Wenxing will present it first.
So, with everything mentioned in the case details, let's turn to the third part of our presentation. The first major point in dispute is that whether the Commission has the jurisdiction to determine the outer limits of the continental shelf over the 200 nautical miles. After we read several essays, we found that this question will be divided into different situations to discuss. Firstly, we have to understand the process of establishing the outer limits of the Commission, which will be the foundation to carry out a discussion. Article 9 of Annex 2 of the Rules of Procedure of the Commission on the limits of the continental shelf, along with the Article 76, paragraph 10, underlines that the actions of the Commission shall not prejudice the matters relating to the delimitation of the boundaries between the states with opposite or adjacent coasts. What's more, A, paragraph 5A of the Annex 1 has played an important part of causing this case, as it says that we quoted at the slides, you can see that, and I would repeat paragraph 5B of the Annex 1 of the rule of the Commission for you guys. The submissions made before the Commission and the recommendations approved by the Commission thereon shall not prejudice the position of the states which are the parties to a land or maritime dispute. All these articles manifest that whenever disputes about the delimitation of the continental shelf has occurred, the Commission has very limited power to settle the conflicts, especially when prior consent given by all the states that the parties to such a dispute is missing. So, how could states to give their consent, or how could we assume that states has provided their consent? According to Article 5A of Annex 1, the meaning of consent must be expressed by all the parties to the dispute. All parties to the dispute must do something to show their acceptance of the submission, which will be considered. Failure to act or take no position shall not be considered as a reference to consent under the Article 5A. So, from the point of view of treaty interpretation, the words implied consent or the tacit consent are irrelevant to this article, which means that the context of the consent is uncompatible. In addition, consent given by all the disputing states was accepted as a clause, which means that each party to this dispute has the right to block the consideration of submission by the Commission. The state concerned has veto power. In this case, on 16 December 2008, the Union of Myanmar submitted the Commission of the Limits of the Continental Shelf. Bangladesh writes a note viable to the United Nations, which state has shown the PowerPoint, and it apparently showed its rejection. This action taken by Bangladesh is obviously not a way showing consent, but a way to show the dispute that existing in this area. The actions taken by the Bangladesh blocked the Commission to take further steps to investigate the submission handed by Myanmar. In this case, we could find that the dispute between these two states was trapped in a dilemma, and the problem will not be solved through the Commission. At 2009, both of the states decided to turn to the tribunal for help. So we could go back to the question, why the tribunal has the jurisdiction to judge? I think the main reason is that the Commission was temporarily unable to play its role, and the way to perform its function is trapped by the existing dispute. At this time, if the tribunal was length of the power to decide the outer line, we can imagine that the dispute between these two countries will linger for a long time, which will on the opposite side of the purpose of UNCLOS. Additionally, instead of arguing the conflicts about the tribunal or the Commission, which stands a better position to control such conflicts, I suppose that we should put more emphasis like how to settle the disputes more effectively. As far as I'm concerned, the relationship between these two organizations is more like complementary, and the delimitation does not affect the establishment of the outer limit of the continental shelf, and the tribunal does not democratize the dispute. The committee will not able to review the views of the countries concerned. So as a result, maritime disputes between the countries are stuck in a dilemma, which some scholars call the black hole of jurisdiction, which is a situation where no organizations have the jurisdiction power. In fact, the Convention's provisions concerning the establishment of the outer limits of the continental shelf and the delimitation of the overlapping areas are unclear. It should be noted that while the Commission is a professional body which existing the coastal states in establishing the outer lines of the continental shelf, the legal issues relating to the rights basis on the continental shelf are not within the function of the committee. Therefore, as a body with the authority to interpret the convention, the tribunal can judge the rights of the countries concerned and the applicable laws for the delimitation of the continental shelf, which can be believed that this ice-breaking attempt by the Maritime Tribunal in the delimitation of the outer continental shelf should not only solve the long-standing dispute between the Bangladesh and the Myanmar, but also encourage the tribunal and the commission to pay more attention to the jurisdictional issue of the delimitation of the outer continental shelf, thus contributing to the clarification of the jurisdiction of the tribunal and the committee.
Okay, you may have some question about why the principle of natural prolongation mentioned in the Article 76 in the UNCLOS should be used on the delimitation of the continental shelf. And I will explain it through the development of this principle. And you can see it on the slide. The Truman Proclamation of the 1945 was the first document to declare sovereign rights over the continental shelf, and what it was expressed is on the PowerPoint. And next, in the 1985 Convention of the Continental Shelf, it was the first international treaty to regulate the right of the continental shelf, recognizing the principle of natural prolongation as the sole basis of the right. A famous continental shelf case called North Sea Continental Shelf Case in 1969 first clarified the principle of natural prolongation as the basis of entitlement to the continental shelf from the beginning. It means that the coastal states use its territory for the purpose of exploitation of the seabed and the collection of natural resources. And next, in Tunisian and Libya continental shelf delimitation case in 1982, the International Court of Justice explicitly asserted that the principle of natural prolongation had become a rule of international customary law. And during the Third Ocean Conference in 1973 and in the 1985 Libya-Malta continental shelf delimitation case, the principle of natural prolongation was emphasized again and again. Thus, it is clear that the principle of natural prolongation had been universally recognized by the international community as the rule of customary international law prior to the judgment of the Bangladesh and Myanmar case. However, the tribunal abandoned this traditional customary international law rule and pioneered a principle of outer edge of the continental margin without giving the satisfactory explanation of its decision. Therefore, we consider this view of the tribunal to be controversial, and it is really questionable that whether the outer edge of the continental margin is of general application and can be progressively transformed into a rule of customary international law in the future. And also, we found that the academic community has not yet reached a conclusion about that after reading several papers. And here is the judgment of the case. You can see the tribunal's delimitation line in the map. At the end, here are two questions for discussion, and we will also put the text on the comment area on elements, and you can see both the questions on it. These are the references of our presentation. And that's all for our presentation today. If you have any questions about that, please feel free to comment or contact us. Thank you for your listening.
Thank you.